I'm organizing today's event together with the Parliamentarians for Global Action, which is a global network of parliamentarians across the world and has been instrumental in the ratification of the Rome Statute in a number of countries. My name is Marietje Schaake. I'm a member from the Netherlands with the Alliance of Liberals and Democrats for Europe. I work on human rights issues and Europe's digital agenda, most of all. I wanted to give you a very short background of what the framework is within which we're going to have our discussion today. We have a pretty tight schedule with a lot of speakers, but at the end there will be room for discussion, and we'll make sure that we end before 2 or at 2. All EU countries are actually state parties to the Rome Statute, and the EU has been a consistent supporter in political sense, technical sense, and the financial sense of the ICC's work. And EU member countries are together the biggest financial contributors to the ICC's budget, actually along with Japan. And this funding is done through the European Instrument for Democracy and Human Rights. We also have a group here in the Parliament called Friends of the ICC, of which my colleague from the Green Group, Barbara Lochbihler, is the chair, and another colleague, Mr. Schulz, is also a member, I believe. And together we paid a visit to the ICC about 3 months ago, which was very helpful in engaging in more in-depth discussions about the relationship between the EU and the ICC. The EU support for the ICC is underpinned by an EU common position on the ICC, which was established in 2003 and has been renewed in last March. Today what we want to talk about is to look at how we can involve members of the European Parliament in a meaningful way when we elaborate the new EU action plan for the ICC, which is designed to give effect to the EU decision on the ICC of this year. And the approval of this action plan is expected at the end of June by the member states, and it will be finalized under the Hungarian chair of the EU Council Working Group. And what we want to do with today's outcomes is to feed those in as key priorities of the European Parliament for this new action plan of the ICC, and we will pass it on to the High Representative for the foreign and security policy of the EU. So we're going to start with a presentation by Barbara Lochbihler, who is from Germany and a member of the Green Group. We have about a half hour for a discussion on the European Parliament's contribution to the fight against impunity worldwide through our policies. So I wanted to give the floor to Barbara, and then I'll introduce the next speakers right before they speak. Thank you.
So first, it's clear that we have made positive progress in the last decade in the fight against impunity. And we have now the first cases at the International Criminal Court. Nevertheless, we see international justice that this issue continues to face a lot of hindrances in its development. First, we have that all states have the right under international law to prosecute and try people responsible for genocide, crimes against humanity and war crimes, and other crimes under international law, such as torture, extrajudicial execution, and enforced disappearances, regardless of the nationality of the victim or the alleged perpetrators or the territory where the crimes were committed. In cases where the alleged offender is present in any territory under its jurisdiction, the state has the imperative international obligation to extradite or to bring the accused to its own national courts. And if we read the newspapers and follow some issues, we see that a number of very different states are reluctant to do so. For example, my own, Germany, have waited quite long and have received information long before they have arrested 2 Rwandese nationals. And on the other, look to South Africa, completely different history. When Mengistu Haile Mariam, the former head of state of Ethiopia, is living in Zimbabwe, And when for medical purposes he went to South Africa, everybody was alarmed to arrest him because to bring him to the national courts in Ethiopia, the governments refused because they don't want to run into difficulties on the diplomatic sphere, let's say it like this. And we see the European Union is determined to work towards the prevention of crimes of international concern and the ending of impunity for perpetrators of such crimes. And the EU has consistently given strong support, being it political, financial, or technical, to the functioning and effective functioning of the International Criminal Court and other international criminal tribunals. This has been done to the EU through the EU Common Position and the EU Action Plan on the ICC. So all EU member states have ratified the Rome Statute, and also all EU member states and Japan, these are the main contributors to the budget of the ICC. And also the budget, and I see here a lot of representatives from different non-governmental organizations. The EU has also contributed to the budget of the Coalition for the Criminal Court, an association for more than 1,500 NGOs in support of the ICC. Also, let me welcome that there is success, that we have more and more ratification. Grenada has ratified the statute on May, also last month, and is now the 115th member state. Despite these successes, there are much more measures, actions plans developed in different departments and working groups of the European Commission, the European Council, and the Parliament, and they are not implemented successfully. For example, when we look at our EU guidelines to prevent torture, and also when we ask EU delegations how strong are they promoting the ratification of the ICC statute, we see that some EU delegations are reluctant to do so. And there's, for example, a very comprehensive and good manual on effective investigation and documentation of torture and other cruel, inhuman, and degrading treatment or punishment. This is a very good manual, and it is essential and a vital instrument for gathering evidence and preventing impunity. Even as a country is in a situation where you cannot get hold of those who order these crimes, it's very important to have good documentation when the historical moment comes or a change in government, that you have good documents who did what. And we also have to be very self-critical on the role of European countries in cases of torture and renditions. This means kidnapping of people and even secret prisons in the so-called war on terror. The European Union has until now failed to shed a light into its involvement in the illegal CIA flights. And the legal community and all the human rights movements must continue their efforts to attain universal justice and an end to impunity.
You did a wonderful job. It's also quite daunting what immense challenges we face with so much violence against people and so much impunity. I also wanted to warmly welcome those MEPs who've joined us since the beginning of the meeting who we haven't had a chance to welcome. Richard Howitt, who was leading the delegation of the European Parliament to the Kampala Review Conference. Sarah Ludford, who will also work on the new report on the ICC that was just mentioned by Barbara. Vittorio Prodi, who is an active member of Parliamentarians for Global Action as well. Welcome. And I know that Edward wanted to say something. He has recently joined Parliamentarians for Global Action, which we're very happy with. And I would also like to encourage everybody to join if you haven't yet and ask colleagues to join so we can be stronger in working on these issues. Did you want to speak about impunity and some other issues? Go ahead.
I've got to leave in a few minutes, but thank you, Marietje, very much indeed, and not only for the invitation to this very interesting meeting, but also to join Parliamentarians for Global Action, which I'm delighted to do. And may I just say, Barbara's excellent tour d'horizon of impunity and the ICC is extremely valuable and I consider myself a friend of the ICC as well. Many years ago, after the fall of the Berlin Wall, founded the EIDHR. At that time, the concept of an international court was not well developed. But of course, the emergence of the ICC on the international stage has been amplified by recent events, as Barbara has stated. And on my only visit to Yemen a few years back, it was on the occasion that President Saleh was actually signing the Rome Statute. He's yet to ratify it. But it does underline how the reach of ICC is spreading. Barbara mentioned Egypt, where I've been now 3 times since the fall of Mubarak, and I can tell her that the Egyptian reformists are talking very earnestly about how to possibly use retrospectively the Rome Statute in relation to some of the more outstanding crimes committed in recent times in Egypt. So in all these areas, the ICC is assuming a greater and greater significance. And one of the most recent meetings I had with American personalities, and Barbara was there too, Sarah was there too, was with Madeleine Albright, where I stressed that the difference between the American approach to the democratization process, the rule of law, and so on, was that the European Union is an essential linchpin of the International Criminal Court and its work, whereas the United States is still sitting on the fence. I say sitting on the fence because I think it is possible that one day the US may subscribe to ICC. And I was delighted to be able to speak at the opening of the Prevention for the Centre for the Prevention of Genocide in Hungary recently. But I think in the end, it is fundamentally an EU responsibility to promote the ICC, to finance the ICC.
We had a really brilliant meeting in Uganda with parliamentarians from Nigeria, Malaysia, Bahrain, Uruguay, Democratic Republic of Congo and New Zealand, and it really brought home to me personally the vitality of this network, and your work here and the follow-up we can do in the European Parliament I think is very, very important indeed, and today's event is a very concrete demonstration of that. And also I'm very proud of what we did as a European Parliament in Uganda. Barbara, who was a honoured and esteemed colleague as part of that delegation, we were together and has given a very full overview, and I don't want to repeat anything that she said, but I think we're extremely, I hope and believe we were extremely effective in providing a strong voice for things that not just we as European parliamentarians believe in, but the citizens we represent believe in at that conference. And I think that there was some sharp differences with some of the other EU institutions in relation to that, but that was probably a good thing to show that there is a diversity of view at the European level. And I'll say no more than that. Now let me address the point in this panel that you asked me to on mainstreaming directly. I think the pledges, and I know Dr. Bierman's going to speak later, so I won't refer to them, but the pledges are important. The pledges actually, folks, are not that ambitious, sorry, if anyone's upset by that. They're the sorts of things one might expect. But not everyone did give pledges. We've given them publicly as a European Union, so the first step must, of course, be to honour them, and as a Parliament we must hold to account the Council and the other institutions for implementing them. So they should be a starting point, and I mean no disrespect to Dr. Bierman and his colleagues in saying that. But of course I think we should go further. I feel very, very strongly that we haven't sufficiently yet used the European Union's external diplomatic muscle sufficiently in relation to human rights issues in general and the International Criminal Court in particular. Barbara and I and other members of the Human Rights Subcommittee have so often been in delegations over the years in third countries worldwide where it is quite clear that in the political dialogue, even in the human rights dialogue, let alone in, and Hellman is here from the GUEs, another great colleague on these issues, negotiations about trade agreements, where there's no even mention of the fact that the country concerned doesn't adhere to the International Criminal Court and votes in particular ways in Geneva that are profoundly in contrary to the EU's positions on human rights. And that's not good enough. And now we've got an external action service. It provides us with the opportunity and removes the excuse for that to happen. And so it's very, very important in every single delegation of the External Action Service worldwide, in every single agreement, be it a partnership agreement, association agreement, a trade agreement, that we now have, that is the opportunity to say, we want you to adhere to the International Criminal Court for those who don't adhere, or for those that haven't translated it into domestic legislation, to get them to do so and to offer help in doing so, and for those who've actually operated contrary to the Rome Statute, like the al-Bashir case that Barbara talked about, for us to hold them to account for that. And I repeat, there is no excuse now as a European Union for us not to do it.
First, I'd like to say that the EU really has played an absolutely crucial role in the ICC's development from a court on paper in 2002 into a fully functioning judicial institution that it is today. The ICC now has 6 active situations under investigation or prosecution, and the prosecutor of the ICC has announced that he will apply for authorization to open a 7th investigation into the situation in Côte d'Ivoire. We have 3 trials ongoing, 2 of them are approaching conclusion. We have 4 other cases at various stages approaching trial, with the suspect already in custody or having appeared before the court. 115 states have now ratified or acceded to the Rome Statute, and others indeed have announced their intention to join in the near future, and we're expecting several new states parties hopefully later this year. Really, all this progress would not have been possible without the strong and consistent political, financial and technical support of the European Union and its member states. And the European Parliament has played a very important role along the way by providing very, very vocal support and backing to the ICC's mandate, and by ensuring the consistency of the EU's policies. And to give just one example of the really excellent work of the European Parliament, I would refer to the latest report on the annual report on human rights in the world, and section of the ICC. It's truly excellent and really covers almost, all the essential things that I can think of. But really, as the ICC matures and moves forward, the court is facing new challenges, and the cooperation and support of states parties and intergovernmental and regional organizations will continue to be every bit as important as it has been until now. And in this respect, we were happy to see the EU's common position revised, and the key principles of universality, state cooperation with the court, and complementarity of the national jurisdictions strongly reflected in that revised instrument. And the upcoming revision of the EU's action plan is definitely an opportunity to put in place even more effective mechanisms that will allow for these principles to be turned into concrete results. And I would just highlight a few issues on this occasion. First of all, the creation of the European External Action Service opens opportunities for further boosting the EU support to the ICC. Really, that the political and diplomatic support, in my view, is the basis for tackling most of the relevant issues where the EU can make a difference. And some ideas for using the External Action Service are, for instance, appointing focal points for ICC issues in EU delegations around the world by providing or ensuring regular briefings or training for the focal points, as well as heads of delegations with ICC issues on a regular basis. And generally ensuring that ICC and impunity issues are really mainstreamed in all relevant contacts with states.
Regarding the challenges that the court has ahead of itself, I think we can start from yesterday's decision of the pretrial chamber on the Kenya situation. And this is really a paradigm of what happened when you really try to fight impunity seriously. The court started to analyze the situation and ended up with 6 individuals being named by the prosecutor, and suddenly those individuals include the vice president of the country, a couple of ministers, and so on. And finally, after 3 years of efforts in Kenya to put forward efforts to end impunity, create a domestic system to end impunity in Kenya, finally the government of Kenya woke up and said, we challenge the jurisdiction of you, International Criminal Court, because we can do the work ourselves. And so they challenged the jurisdiction of the court, and yesterday the pretrial chamber said, I'm sorry, too late, not good enough. Your intention to prosecute is not sufficient. You should have done it earlier. Now we have a case, and we will proceed until the day in which you will have an equivalent case against those individuals. And by doing so, the pretrial chamber also highlighted that it is not only a right of states to exercise the jurisdiction on Rome Statute crimes, it's an obligation. It's a pre-existing obligation. It's not written in the Rome Statute. Well, it's written in the preamble, of course, but it's also written in other instruments like the Genocide Convention or customary international law, where it's unwritten law. And as Barbara Lochbihler told us, there is an obligation either to extradite or to prosecute. But unfortunately, the rule has been so far neither to extradite nor to prosecute and leave those individuals under a condition of impunity. So I think we can say that thanks to the ICC and the presence of the ICC, now we are finally narrowing the impunity gap. That is the historic change that we are witnessing today. And even though the cases in The Hague are very few, thanks to this obligation of implementing the principle of complementarity, we can maybe reach in the future a wider impact of this system on the fight against impunity at the domestic level. So the first challenge, as far as I am concerned and PGA is concerned, is that we need to strengthen domestic tools to end impunity. We need to strengthen national systems. Yesterday we organized a meeting in the Swiss Parliament on sexual violence in the DRC, and a member of our network from North Kivu witnessed before the Swiss Parliament how many women have been raped over the past few weeks in a region with no possibility of anyone to interfere and stop those atrocities that have been repeatedly denounced and condemned by the Security Council through resolutions, by the international community. But the UN forces on the ground, MONUSCO, is not equipped to arrest those alleged criminals. They don't have the mandate, they don't have the skills, they don't have the training. So one of the outcomes of that meeting that I bring back to the table today, and the challenge that we have, is that we have to strengthen the civilian component, the police component of peacekeeping operation, to ensure that those who are on the ground are able to carry out arrest operations. We have seen that in Sierra Leone, when the intervention of the UK finally led to the arrest of Foday Sanko, and basically led to the end of several years of civil war. We have seen it also similarly in the Côte d'Ivoire situation, where very few special forces were able to facilitate the end of a conflict, and finally Mr. Gbagbo and his wife were delivered or were arrested by Ivorian authorities, and soon the prosecutor will launch a request for an arrest warrant regarding their alleged responsibility in the commission of crimes against humanity in Côte d'Ivoire. I'm saying this because that's where we have a gap. We are not able to execute many arrest warrants. There is Kony and other 4 leaders of the Lord Resistance Army at large. They are indicted since 2005 for crimes against humanity. They are committing again the same crimes, not anymore in northern Uganda, but in the Central African Republic, in the northeast of Congo, and even in some region of South Sudan. There is a need to intervene, but there is a lack of means. There is a lack of capability. The international community is not ready to do so. The Bashir case has been also mentioned. That it is even more complicated because Mr. Bashir is a sitting head of state, fully in control of a state machinery. So that would not necessarily and simply require an arrest operation. That would require much more long-term operation. But that's where I think we have a big challenge, because we don't have yet the tools to give effect to the mandates, to the arrest warrants issued by the ICC.
Let me thank you first of all the organizers for organizing this event. I think it's a very important event, and it shows again the crucial role of parliamentarians, and particularly, of course, our parliamentarians in the European Parliament when it comes to the ICC. Now, I've been asked to talk about the EU and the ICC relations and the way towards the new EU action plan to the ICC. So give something like a sneak preview of what is going to be expected to come out of the currently ongoing revision process of the action plan. And I will do my best to reveal as much as possible. As you know, the process will be finalized by the end of this month, with the end of the Hungarian presidency, and in a month's time we will all know more. But let me start by, before I go into details on the action plan, start by stressing again what are our key political messages and what is our legal basis, which is important, of course, for answering the question what we can do on the European level and what we can't. Let's see if this works. So the political message, of course, is clear and remains very, very strong and clear. That we are a staunch supporter of the ICC because we believe there shouldn't be any impunity for the most serious crimes. Also, we support an international order based on effective multilateralism. So this is why all EU member states have ratified the Rome Statute and why we can have this relatively strong policy on the ICC. It is also clear that the principles of the Rome Statute are fully in line with the principles of our legal basis. I walk you quickly through this. First, of course, the Treaty on European Union makes it very clear right in the beginning, Article 2, what our values are. You can read all yourself. Rule of law and respect of human rights are among them. And Article 3 makes it clear that the Union has to uphold these values and promote them in its relations with the wider world. Article 3 goes on by saying that we should contribute to peace, security, and the protection of human rights, and also on the development of international law. A very relevant clause also when it comes to the ICC work. Then we have the Article 21 that spells out that our action on the international scene has to be guided by certain principles, and these principles again include human rights, respect for human dignity, respect for the principles of international law. And the Treaty on the Functioning of the EU makes reference to these principles again in Article 205. So we are, legally speaking, we are pretty well covered when it comes to the external side. Obviously, the EU has no competence, for example, on military matters. This is one of the things that comes sometimes up in this respect with the ICC. But apart from that, we're pretty well covered. And on the basis of this legal basis, the Council has revised its common position and adopted what is called now the Council decision in late March. And this Council decision lays out 5 clear objectives. Coordination of EU activities to implement the objectives of the decision, universality and integrity of the Rome Statute, independence of the court, and effectiveness and efficiency, cooperation with the court, and complementarity. On the basis of this decision, we are currently, as explained, revising under under the presidency of Hungary, who is presiding the responsible working group in the Council. And as I said, we hope that the revision process will be finalized by the end of this month.